Thank you, Chairman. I'll be very brief. I first wanted to say that I was one of the original co-authors, co-sponsors of one of the two measures that have been combined here. And when the decision was made to go forward on a 2-by-2 basis, I stepped back, but I kept a very close eye on the negotiations that continued forward. And I just want to join other colleagues in thanking Senator Tillis, Senator Graham, Senator Booker, and Senator Coons for the good work that they and their staffs did, and echo the comments about the extraordinarily productive and helpful role that you and your staff played in bringing a slightly variegated issue, perhaps I can say that without dispute, into a form where we got a strong bipartisan vote today. I appreciate that very, very much. I do wish to make the point on my own behalf that I don't think we need to assert that Morrison v. Olson must stand as it is in order to defend this statute. I think that this statute would stand on its own merits, even if the Supreme Court were to considerably reconsider Morrison v. Olson, in the same way that we allow civil service protection, which includes judicial review of unlawful and improper firings for the public purpose of protecting against over-partisanship and the spoils system in the executive branch. There's every reason to believe that judicial review of a firing in this case would withstand constitutional scrutiny on its own muster, because there is a similar public policy involved. You don't get special counsel unless you have conflicts of interest. And to have the public assured and to have the Constitution operate in such a way that we can guarantee that the rule of law exceeds conflict of interest, that it trumps conflict of interest, I think is an important principle that the court would uphold if this law were to come before it. The last thing that I will say is that I am very pleased that the chairman's amendment has protected a principle that I consider sacrosanct, which is that during the conduct of an ongoing investigation, the investigators and the prosecutors never be put under any ongoing obligation to report in or otherwise make disclosures to Congress. In Rhode Island, I was the Attorney General of my state. It's a state where we don't have DAs. There are 3 states where the Attorney General does everything, and Rhode Island is one of them. So I've overseen an awful lot of criminal practice, and the notion that I should be obliged to check in with the Rhode Island General Assembly in an ongoing criminal investigation makes my head want to explode. That is, I think, a truly intolerable intrusion on prosecutorial independence and investigative secrecy, which are essential for the enforcement of our laws. It is no different coming here to the federal level for a U.S. attorney to be put under some stricture that in the course of an ongoing criminal investigation, he or she should be obliged to check in with Congress and update them on the status of the investigation is equally head-bursting a theory. So I'm glad we have steered well clear of that. That would have been to step into a very, very dangerous and unprecedented area with huge damaging repercussions. So I particularly appreciate all of the negotiators having steered us clear of that particular bear trap. So with that, I conclude my remarks, but with great appreciation again, Mr. Chairman, to you and to your staff.
Okay. Senator